Good afternoon from Hong Kong. Welcome to this Privacy Rules webinar. And in the course of this afternoon's proceedings, which are captioned Global Breaches, Regional Responses, from AI to Incident Response. I am the moderator for your first session. My name is Podrick Walsh, and I am a partner in the Hong Kong independent firm Tanner DeWitt. We are also the member firm in Hong Kong for the Privacy Rules Alliance. And maybe a brief word about Privacy Rules. Privacy Rules is a global alliance of technical experts, data privacy lawyers, and communication firms that are specialized in handling matters relating to personal data, whether that's the policy and planning perspective or the incident response actions that are needed. We are global in nature and work as a cohesive team to be able to respond to incidents that might happen to you and your other needs in relation to personal data protection and privacy. Now on to today's first session. This session is going to focus on personal data breaches and give you an insight into some regional differences that arise across Asia Pacific. Our chosen countries for today's session are Japan, Taiwan, Hong Kong, and Australia. And in order to address those, we have an extremely good panel to be able to share their expertise and insights with you. They are Sarah Chen from Eiger Law in Taiwan, Minako Akita from Iwata Godo in Japan, and Mark Metzeling from McPherson Kelly in Australia. Now, across the course of today's session, I think one of the things we really want to highlight is as much as you will have a regional or even a global response plan for a data breach, one of the challenges you will face in any incident response are the differences that arise from place to place. There may be a degree of commonality, but you will find nuances and differences in culture and differences in approach that you must be mindful of as you navigate the crisis that might have befallen you. And with that, I'd like to turn, firstly, just to get a sense check in respect of where the particular requirements are in each jurisdiction from our panelists. So if I could ask each of you, in a brief answer, ideally yes or no, to let us know if there is a mandatory data breach reporting requirement in your jurisdiction. Sarah, starting with you in Taiwan.
Okay. In Taiwan, you are obligated to notify the affected data subjects after the facts are clarified. And as to the reporting to the authorities, that because it is regulated in the specific regulations, so first you need to check what industry you are in. So you may check the regulation you apply and whether you hit the threshold. If you hit the threshold and you are in that regulation, so you will need to report the data breach to the authorities, industry-specific authority, within 72 hours after
Okay.
you are aware of the incident. Yeah,
So it's sector specific.
yeah,
Okay.
yeah. You need to, yeah.
Minako, if I could ask you in Japan, is there a mandatory data breach reporting obligation? And if so, what's the reporting timeline?
Yes, there is. Businesses must submit an initial report to the Data Protection Authority promptly after they become aware of the incident. And the guideline provides that what is considered promptly depends on the case, but it's recommended to report within 3 to 5 days.
Okay. And does that apply to just the regulator or also an obligation to notify affected data subjects?
Businesses do have to notify the data subjects, but that can happen later on. There
Okay.
is no
Not so,
specific deadline.
not so promptly.
Not promptly, yes.
And Mark, how about Australia?
So Australia, we adopt what's called the as soon as practical approach to notifying the Office of the Australian Information Commissioner. So in essence, it's been taken to generally mean 30 days. Within 30 days, that notification has to be in. However, the sooner you can get it, the better. And if you're seen as waiting too far along, then it can have adverse consequences when it comes time to determining whether a fine or penalty should be issued. So, the sooner you do it, the better. And similar to Monaco, what she was saying with notifying businesses and the people who had the data breach result, they only need to be notified within the next period. So you generally notify the Office of the Australian Information Commissioner and you let them know what steps you're going to take, and then you go and take those steps of notification.
Okay. And is that countrywide in Australia, or is it something that varies according to the state?
Yeah, no, it's countrywide. So this is federal legislation, the Privacy Act in Australia. Each state has their own Privacy Act. However, that only applies to government institutions within that state. So the federal government can't tell the state governments what to do, or the local councils. So the state governments have to pass legislation which mirrors the federal legislation in each state. But for businesses, it's all dealt with at the federal level.
And maybe just to share briefly in respect of Hong Kong, in Hong Kong presently, there isn't a mandatory, horizontal or general mandatory data breach reporting obligation in respect of personal data to our privacy regulator. It's certainly strongly recommended, but it's not a requirement. There will be some requirements arising from regulation in specific sectors, primarily the financial services sector. There are proposals for reform, but those proposals for reform have been out for close on 5 years. So to use an Irish parable, it might be a little bit like waiting for Godot. We might see it one day. Moving on, and maybe just turning to our theme in respect of differences in culture, we already have some variations in respect of some hints as to what that culture is. I think of Monaco's reference to an obligation to notify promptly, and also some variations in respect of the notification timeframes across the countries we're looking at. I wonder if we can explore themes of culture a little bit more deeply. And Monaco, one of the things that we spoke about before in our preparation was the culture within Japan to almost notify just in case, that there is a tendency to notify to the privacy regulator, even in respect of, shall we say, data breaches or incidents that are not so material. How has that influenced the trends in respect of how the regulator views data breaches, and maybe even some of the changes that are coming in legislation in Japan? We can hear you now.
Thank you, Padre. So, okay, good, perfect. So, yes, according to the authority, more than 10% of the data breach reports were made voluntarily, meaning that they didn't fall under any of the cases where reporting was mandatory. And one possible reason for this is that in some cases, it will take some time to investigate the scope of the breach or the cause of the breach to properly assess whether the incident requires mandatory reporting or not. But since the initial report must be submitted within 3 to 5 days after the business is becoming aware of the incident, they decided to submit the initial report just in case they found out later that the incident requires reporting. And in light of this trend and the fact that businesses have been complaining that this initial reporting system is causing some burden on them, easing the rules for mandatory reporting is under discussion as one of the areas of amendment of data protection law in Japan. And one idea being discussed currently is that for businesses that are certified by a third-party certification body, that they have in place an appropriate data breach response system internally, the initial reporting obligation will be exempted, and they will only have to make the final report, which is due within 30 days generally, or 60 days if the cause of the breach is due to fraudulent purposes.
Okay. And where is that in the legislative channel? Is it a change that's likely to come about in the next 6 to 12 months? Is it that kind of time frame?
We were hoping so, but no. The draft law was not submitted to the current diet and the parliament in Japan. We hope it will be submitted during the extraordinary diet period sometime later this year. But if that doesn't happen, it'll be submitted next year. So it won't be until maybe a year and a half until this amendment will come into force.
It's interesting in this sense that if you look at it from a regulator's perspective, if they receive too many notifications, they then have to develop a method in terms of how they assess those notifications as they're arising, and then move forward in terms of in terms of actions. It is one of the things that is different in a country where there is a data breach notification obligation. It by its own definition, it increases the workload on the regulator. One of the things in contrast that I've seen in Hong Kong is that oftentimes the degree of attention that our privacy regulator gives to voluntary data breach notifications is perhaps higher than would be the case if they had a higher volume of data breach notifications. So it's interesting that what the law requires also influences how a regulator responds. And on that, Sarah, if I could turn to you, we've already touched upon the sector-specific regulation that applies in Taiwan. How does that extend or complicate the reporting lines when it comes to reporting data breaches?
Yeah, although there's the privacy regulator and then the Personal Data Protection Commission, but currently still a preparation office. So before that, we call the PDPC. The commission is formally established. The current competent regulator remains is scattered, it's not centralized, and is industry specific. But with the PDPC serving as the kind of the supervisor. And for example, if the entity is in some cosmetic industry, and the competent regulator will be the Taiwan Food and Drug Administration, yeah, the TFDA. But in practice, the TFDA will assign the local health department of the local government where the entity is situated to be the main authority to conduct the investigation and to communicate with the entity. So, like in practice, the entity will receive the official letters from that health department of the local government, and we reply to them. A reporting line would be the health department of the local government, and they will report to the TFDA. Then the TFDA will report to the prep office of the PDPC. And if PDPC have further questions, they have something they want to know further, and this information will convey at the same there to there to the entities or client. So I think the impact of this layer communication is that we always suggest our clients to respond in a written form, because sometimes that we will receive phone calls from the authority like we want to clarify some issues, can you give us some feedback on this? But that's when we'll push back and say, oh no, we prefer the written communication, because we cannot make sure that if that through that layer that the information might be not adequate, something like that. So, and also I think as you can expect, this is back and forth communication and will make this whole procedure lengthy. So it's kind of I think the main difference is that we don't have a centralized authority now. So it's kind of hard. You need to determine which industry you are in and which authority you would need to report to.
Do you know, it reminded me of those scenes in movies where there's a fire. A fire is always a good image for a data breach session. And you have a chain of people passing buckets of water along so that by the time it gets to the fire, the bucket is empty and the fire continues. But I guess there isn't a requirement for you to wait as such for a regulator to respond and give directions. The company in question can take immediate steps in respect of stopping the breach and remedying the breach. So the main risk, I guess, is miscommunication and possibly communicating to the wrong regulator, to the wrong party.
Yeah. Although we see that the regulator might pass the case by themselves, but yeah, it's
And Mark, you mentioned that there is a change in reporting culture within Australia and that there are changes afoot in terms of navigating that, including in respect of some guidance that may have come out on dealing with data breaches and ransomware.
Yeah, so in Australia, I guess the long-term culture has been a case of resistance to reporting, and quite opposite to the Japanese approach, I might say, where businesses want to report and just in case. In Australia, it's more like, we don't have to report this, do we? Because there's always that fear of fines being handed out by a regulator. However, with the reporting of more and more data breaches in Australia, it's now businesses are starting to get more comfortable with the fact that if they report early and take the correct steps and have things in place, such as a data breach response plan, and have those sort of things sitting there, then the regulator's not fining them because they're saying, well, you've done everything you can to minimize the prospect of loss of third-party information, and it's been pretty much a third-party act, or it's been some unforeseen circumstance that's come about. And so speaking about those third-party acts now, I think it was recently, within the last couple of months, that Australia passed legislation now making it mandatory. It's always been mandatory to report data breaches, but now it's also mandatory to report the payment of a ransom if a data breach has occurred from nefarious means. And part of that reporting also has to be a case of reporting how much you've paid for the ransom. So, and the rationale behind that is so the Australian government can understand what the cost benefit analysis is for the businesses, so if they're paying, large ransoms, small ransoms. And so this is now mandatory. And I guess that is now, it's not so much of a fine perspective that's driving it, but more so just wanting to know how to navigate and how to implement better policies around that so that hopefully these ransom attacks can be lessened.
And within that, in terms of how that's been received by the business community, is there a concern that by reporting ransomware details, that they may well be open to some form of exposure liability? And how has the regulator kind of taken steps to mitigate that concern?
So the reporting is not made public per se, so it might be anonymized. So what the regulator will do is at the end of each financial year, they might say over X million dollars was paid by Australian businesses to ransomware company. In response to data breaches that were held for ransom or something like that, ransom attacks. The businesses, though, I think it's more of a case that they would be concerned that the Australian government would have a data breach, which could then allow access to all of that information, which would identify which businesses are willing to pay a breach and how much they're willing to pay for a breach. And that's probably the more practical perspective, because if the nefarious actors suddenly go, oh, well, Australian businesses are willing to pay up to $5 million for a ransomware attack, why don't we just up our number of ransomware attack on businesses and just keep our demand payment below that, and it'll go through, rather than resistance.
Well, a data breach to the Australian government, that would never happen, would it?
You say that tongue-in-cheek, Patrick, because of course we have actually had one recently where, which was a very famous one, where one of the law firms acting for the Australian government here in Australia, they actually were subjected to a data breach, and it exposed a lot of government information to the dark side of the net.
But one of the things that I think is also interesting, yes, it was slightly tongue-in-cheek, that from what you mentioned was that behind it is the policy of gathering information, and to an extent that the policy also, it means that we won't, that not to disclose specific details, just in order to raise levels of awareness and information rather than making everything public. And Minako, that links to something that we spoke about in respect of the approach of the regulators in Japan to investigation reports and the extent to which they work with the victim of a data breach in a more facilitative and cooperative way, rather than looking at publicity as being the end goal. Could you explain more?
Yes, so in Japan, data breach reports are not published by the authority. The fact that a data breach occurred may be made public only if the authority issues an administrative order against the entity, and it also depends on the severity or the cause of the breach. But in any case, the data breach getting published is very limited. And in my opinion, this kind of approach encourages businesses to make reasonably honest reports to the authority, which enables the authority to obtain reasonably accurate information or statistics about data breach. And this will facilitate the government in amending the data protection regulation to find a better balance between protecting rights of individuals and fostering business activities at the same time.
It's curious because in Hong Kong, actually there's quite an active approach in respect of publicity. So if there is an investigation report, it will be published, and it will be quite clear in respect of the what happened, whether mistakes occurred, things that could be improved, and also the measures that the PCPD, the Privacy Commissioner for Personal Data, sanctioned in respect of the particular investigation. Part of that, I think, is because the privacy regulator doesn't itself have fining powers. And in terms of particular prosecutions of offenses, it's something that is conducted by the Department of Justice, and usually for failure to comply with directions of the privacy regulator in practical terms. So it's often the case that the way the law is set up, and to a certain extent the culture of the regulator itself, influences the degree to which there's public disclosure of these things. Maybe moving on to some questions in respect of how we would approach data breach instances in our own countries. Firstly, could I just check across the panel, in terms of adequate status with the EEA, with insofar as GDPR is concerned in Europe, just to check where that sits. So in Japan, Minako, let's start with a good news story.
Yes, we have adequacy status for GDPR purposes, yes.
Okay. And Taiwan?
Yeah, we have our own Personal Data Protection Act, which we think as the simplified version of the GDPR, but not as strict as GDPR. So, yeah, so following our act will not necessarily means you fit the GDPR. Yeah.
Yes. And how about Australia, Mark?
Unfortunately, not. We're not approved at an adequacy level for GDPR purposes. Instead, we have to generally apply the supplementary rules from the GDPR.
And likewise in Hong Kong. I guess what that means is that in circumstances where there is a data breach where the data controller is cited in the EU, when you're looking to APAC, you are dealing with a range of different requirements and rules, and you cannot assume that a GDPR standard will necessarily apply across the region. It might in some cases with variations, but it is not the norm. It's more the aspiration rather than the norm amongst privacy advocates. But let's take a hypothetical scenario. Let's say that there is a data breach that occurs. Let's take it in a classic setting where, to use a classic, maybe Australian scene, you're at the beach, you're having a barbecue, and your mobile starts ringing, and hey presto, it's your multinational client who's reporting to you that we've had an incident in Europe, and we have a bunch of data subjects that are in Australia, and we need some advice as to what to do. So Mark, what would be the first piece of information that you would like to receive, or the question that you would ask? And then,
well, I guess,
sorry, we'll deal with the information you would ask first. Yes.
yeah. Well, the first thing I'd probably say is, when are you available to have a Teams meeting with with me? Because it's critical straight away. And then
And please excuse my bare chest and shorts, yeah?
That's right. Yeah, even if I have to just hook it up off the beach and have the seagull in the background, it's imperative to get that initial conversation, because then you've got 100 questions. It's along the lines of how many people has it affected, what level of the data breach, have you locked down your systems, all those things will start playing out, and you'll need to know what's affected, whether it was a third-party ransomware attack or was it an email data breach. So each of those questions will then lead you through to a myriad of different pathways you can choose. So that's why I guess there's no real one point of information needed. It's a case of saying, hey, we need to get your CTO or your CIO on the phone with us, and let's start going through those explorations. And it may even be a 2 to 3 hour initial meeting that may have to occur, because that initial day or two is so critical.
And Minako, if I could ask you, and this is reflecting one of the questions we've received from people in our audience, in circumstances where there has been a data breach reported elsewhere, and in a circumstance, how would that influence the kind of advice that you might give if in respect of affected data subjects that are in Japan?
Well, even if the incident is already reported elsewhere, whether it has to be reported in Japan will be assessed under the Japanese data protection law, if the Japanese data protection law applies. So the fact that it's reported elsewhere will not really affect our assessment under Japanese law. We will do a separate assessment.
A separate assessment. You probably, I know that it's one of the things that is interesting in Hong Kong is that because we don't necessarily have a statutory obligation to report data breaches, when there is a data breach that has been reported elsewhere, it's more likely that the company will follow the recommended best practice of making a voluntary report to the PCPD. And in those circumstances, we would always look for, in addition to the general information in respect of Hong Kong, to customize and make it specific, but we would also look for the details of the report that they have made elsewhere, so that we can maintain consistency, but also make sure that what we're doing is in line with what PCPD privacy regulators would be seeing in different places. Sarah, if I could ask you, what would be the immediate kind of steps that you would take in terms of giving practical advice in these circumstances where you've been contacted on an urgent crisis basis? What would be some of the first things that you would want to bring to the attention of the client to say that they should do and to protect themselves and take remedial steps?
Yeah, I think the first question because as mentioned, is our reporting obligation is in some other several industry-specific regulations. So the first thing, like I would ask whether you has a local presence in Taiwan, like a branch or a subsidiary, is because practically speaking, if you don't have a local presence, we don't think our if you report elsewhere, but we don't think our authority will find our jurisdiction can extend to you if that entity don't have the local presence. So if the entity and the main business is what is kind of weird, but I think it's the first question I would ask about the entity. And although we do have the 72 hours reporting deadline, but I think it's important to, if you can keep track on the ongoing investigation, that is fine. You can just say something you know as of now to the authority, and you can say, oh, we are still undergo some investigation. So I think I would suggest the clients to keep the good track of the results of the investigation process and results and the measures they take to prevent or mitigate the damage, the risk, something like that.
One of the things that is also consistent across what we've discussed is the rather short timeframes you have in respect of making a response or reporting or meeting a reporting obligation, which puts a degree of pressure in respect of how available you are and how you are able to respond when an incident occurs. If I could ask Mark, in terms of, at Macpherson Kelly, how have you equipped yourselves to be able to be available when clients call, try to get in touch with you? Do you have particular methods of or communication channels that make sure that they get the attention they need?
Well, there's a few of us that actually officially know, but unofficially and practically, there's a few practitioners such as myself and Kelly Dixon in our Melbourne office. When we deal with international work such as this, we make sure that we are available on our phone basically 24/7 for that particular circumstance, So even if I am down the beach or something like that, or at a barbecue, I might have a quick look at the phone every now and then to see if there's been a message or an email or something like that. So from that perspective, we make sure that we're available, and we make sure that there are people within our teams at any stage able to facilitate the immediate response.
And one of the this kind of constant availability is something that people within data breach work, get very comfortable with after a while. It's a next level up in respect of lawyers always being available. But if one of the things that was even interesting in the hypothetical that we explored was that the client contacted the lawyer relatively early or almost immediately after the data breach. So Minako, if I could ask you, I would say that's recommended best practice, and largely it's driven by reasons related to legal professional privilege. But could you explain, firstly, does legal professional privilege apply in Japan? And is it similar in terms of a recommendation that by virtue of contacting the lawyers first, it helps in respect of giving a degree of privilege and confidentiality over how you respond to a breach?
So first of all, to answer your first question, no. Japanese law does not recognize a broad attorney-client privilege like in the US or the UK. So it is not that common to pre-engage lawyers to be ready for potential data breach incidents. And usually we get consulted by our client after they have done some internal investigation and has a general idea of the scope of the breach. But especially when the breach, the subject data is across multi-jurisdictions, it is highly recommended to contact lawyers at an early stage so that, tell this to my Japanese clients, especially because in Japan, the initial reporting deadline is not that strict. It's within 3 to 5 days, and it's even allowed to report after that, depending on the case. But in other jurisdictions, this deadline is fairly strict. So, and 24 hours, 48 hours can easily pass when the company's sort of in a panic and trying to figure out what's going on, the scope of the breach and everything. So we tell our Japanese clients to contact us as soon as possible, especially if the personal data, the data subject is not just in Japan, but that's in nowadays where data is, and Japanese companies processes data from all over the world. That's usually the case. So we tell the client to just call us and message us whenever you aware of a data breach in your company.
This is really interesting, because one of the things that we say in Hong Kong to our clients is that by instructing us or having a pre-engagement with us, it allows privilege to apply in respect of, firstly, the engagement of other providers like the technical experts in cybersecurity, communications firms, and other people, so that we can act as a coordinator of those services, and their reports, particularly their draft reports, become subject to privilege. I mean, the main advantage of that we find, just by way of contrast, is that if the draft reports come to us, it's not that you change the facts or you change the report as such, but you may be able to give guidance as to giving equal, if at least appropriate weight to the measures and the things that the client or the company did well. Because there's often a tendency, particularly when you're doing investigations, to look only at what went wrong as opposed to the things that went right. And in that sense, it's a very important role, because the report that ultimately either is provided or forms the basis of a report to respond to a regulator's inquiries can then be something that aligns to the reality and the substance of how the company had behaved and also responded to the incident in question. Is that something that's it's probably worthwhile just checking across the rest of the panel? In Australia, Mark, how does privilege apply, and how does it work in terms of how you would advise clients?
Yeah, it certainly does. And what we do is very similar to what you outlined in Hong Kong. And one example I might share with everyone was actually a cross-jurisdictional matter where we were assisting a Japanese company who had an Australian subsidiary that had a data breach in Australia. And what happened was the Japanese company is very forthright with giving all of the information and giving everything and saying, we're very sorry, this was done, it's our fault, and willing to put their hand up straight away. And sometimes, especially with Australia, what you don't necessarily need to divulge all of that information. And so what you were saying, Patrick, is correct. You want to have that lawyer as almost that gatekeeper of the information to be able to say, well, yes, we're not changing any of the information, but we're not going to disclose something we don't need to disclose. And we're going to definitely emphasize those positive things, such as all the training that's been done, the steps that have been taken, how quickly we've responded. And just from that cultural perspective, we found that we really had to press to get a lot more of the positive stuff that had been done correct from the Japanese client, as opposed to what had gone wrong, because they were very forthcoming with what had been done wrong, but we had to really almost extract the good stuff that they had done right so we could balance out that data breach notification.
Yeah, one of the ways I've heard cybersecurity reports and advisors described is that if you were to imagine that you're going out on a date and you're speaking to a very attractive lady across the table, and you have spinach caught between your front teeth as you're speaking, well, a cybersecurity technical expert is the person who will tell you that you've got spinach caught on your teeth. whereas a more polite or diplomatic consultant might turn the other eye or say, well, all the rest of your teeth are perfectly fine. So they do tend to give a warts and all picture. Sarah, could I ask you, is there in terms of cybercrime and involving the police, how common is that when it comes to data breaches in Taiwan?
I don't think that's it appears not a common culture of report the cyber crimes to the police authorities. I think it's only when they involve some fraud or some money transferring issues. But the thing is, if someone reports to the police might report to the regulating authority of the data protection, then that case will be transferred to the data protection authority.
Yes. So it becomes almost a circular report, as we had discussed and described before.
Yes.
One of the interesting questions that has come from our audience is a question about how do we manage or get involved in information sharing and just the challenges in respect of that incident response, that immediate 24 hours or 72 hours after an incident, where things are happening across jurisdictions. So maybe if I could start with Minako on this. In that circumstance where you haven't been pre-engaged, what are the immediate steps that you need to follow in order to be, firstly, on the right side in respect of the advice you need to give promptly and quickly? And secondly, assessing what other help you need in respect of other locations for your client. Could you walk us through that?
Well, if the request comes from a Japanese client and they come to us saying that, oh, we have the personal data breach concerns data subjects in EU, the first thing we do is contact a local council and ask them to be, ready to answer any questions we have or to lead us through what the company needs to do in terms of GDPR. And usually the questions we have is similar to what the EU local council has or councils in other jurisdiction has. So we are the ones who ask the first questions, and we share them with councils from other jurisdictions, and we ask them whether they have any additional questions they have. The key is just to have, be able to communicate 24/7 with the other councils.
Yes, I think one of the things that is a saving grace is oftentimes the information you need to gather for initial reporting tends to be relatively similar across different jurisdictions. And I guess in terms of the role of the lawyers, the lawyer who is closest, as in the jurisdiction of the data controller, is most likely to be the conductor of the orchestra of legal advisors that would be involved also. So that's what usually tends to happen is that the where the data controller is, the advising lawyer there takes the lead in respect of managing conflict clearance and getting an initial feedback in respect of the other jurisdictions involved. It's one of the areas where being a member of privacy rules is especially helpful, because even if there are data subjects in far-flung places, it's quite likely that there will be a member firm of privacy rules in that location, and therefore the ability to be able to pick up on what is needed very quickly in those locations. In terms of looking at the other service providers that may be needed or may help in these circumstances, I think one of the things that is also worthwhile pausing and thinking about, and Sarah, I might direct this to you, is in relation to reputational damage and what that means in the long term. In that sense, do you frequently need to engage with communication firms and such in terms of providing a more business-focused service in communications than necessarily lawyers are equipped to provide?
Actually, I think it's our culture that also the companies usually they are reluctant to report to the authority, and that one thing I think they might thinking is to avoid some press release on the data breach incident. So usually we don't think unless something is like revealed by the press, or in some special cases that there might be some customers that report to the press or something that in that case that we might need the PR expert in that case. Other than that, I think the company's goal is not to make this information public. Yeah.
And there we have it. If you just we've come to the end of our session, and maybe just to recap in respect of our themes. I think over the course of the last 45 minutes, we've reflected how varied and diverse a region Asia Pacific is. That you will have some locations where there are no mandatory data breach reporting obligations, others where there are, and others where you report to the competent sector regulator as opposed to a national regulator. And then you have differences in respect of the approach of the regulator, and also whether or not things such as legal professional privilege are available to you. So it is a complex situation, but one of the things about complexity is that there are also professionals there who are available and able to assist you. So thank you all for your attention, and let us bring this first session to a close. Do please stay with us as we move to our second session now.
Hi, greetings from Singapore, and welcome everyone to the second session of our Privacy Rules webinar today. I am Winnie Chang, the Managing Director of Orion W, a Singapore-based technology law firm. It is my pleasure to be here with you today as your host and moderator for this session. So for those of you who are just joining in, Privacy Rules is a global alliance of privacy and data protection experts from law firms and consulting companies from more than 60 countries worldwide. So now, moving to today's second and final webinar session, we will be focusing on the topic of using AI in the workplace, insights from Australia, China, Singapore, and Hong Kong. So as you know, this is an exciting area as AI adoption continues to shape the future of work in very profound ways, particularly across these key jurisdictions. So we are very excited to have distinguished speakers today who will be sharing their thoughts on the implications of AI adoption within the workforce and regulatory developments in this area. We will also be exploring some best practices for mitigating data risks in AI deployment and maintaining the balance between leveraging AI for productivity and ensuring data security and compliance with privacy rights. So without further ado, I would like to introduce our panel speakers for today's session. And we are delighted to welcome back Patrick Walsh, a partner in the Corporate and Commercial Department and TMT practice at Tanner DeWitt in Hong Kong. Next, we have Mark Metzlin, who's a principal lawyer at McPherson Kelly in Australia. And Zheng Wei, a partner at Dahui Lawyers in China. So welcome everyone to our panel. As for me, I'm from Orion W, based in Singapore, focusing on TMT kind of practice areas. So I've been looking forward to today's discussion, so let's dive right in. So AI is in the early stages of being integrated into the workplace, and with it comes uncertainty about regulation. What is the overall approach for AI regulation in Hong Kong, Patrick?
Well, it probably won't surprise you to learn that in Hong Kong is quite a free economy, so it's not going to lead with legislation. I think the best way of describing Hong Kong's position is if you could imagine an axis in which you had a vertical axis that represented prescriptive laws and a horizontal axis which was more focused on whether there were published guidelines and such from different industry bodies. Hong Kong would be low on the vertical and very far right in terms of the bottom right quadrant in respective guidelines. So unlike, say, places like the EU, where there is prescriptive legislation in place, in Hong Kong there isn't, and there are no plans to be. That may change as AI evolves. But what you do find is that AI and AI development is at the core of government policy in respect of economic development in Hong Kong. So there's a lot of facilitative policies and guidelines to encourage AI development, but also to give guidance in respect of the ethical and appropriate adoption of AI in the workplace and in government and in other parts of the Hong Kong economy. So there are a lot of guidelines that have been published by organizations like the DPO, that's the Digital Policy Office for the Hong Kong government, for the Monetary Authority in respect of banks and financial institutions, and also the Securities and Futures Commission, even the Law Society and the judiciary. So across different parts of the economy, there is guidance that's coming out from regulators and supervisors about the best approach for businesses and those within its subject to its oversight to adopt, adapt, and deploy artificial intelligence systems within the workplace?
I'll say a few words about the position in Singapore. The regulatory landscape for AI is still evolving. While there is no AI-specific overarching legislation in Singapore, we do have a practical model AI governance framework that gives businesses very clear guidelines on how to deploy, AI responsibly, with a very strong focus on factors such as transparency, fairness, and accountability. We also have an existing Personal Data Protection Act that requires that businesses do handle personal data very securely, something that's very crucial when you're talking about AI in the workplace. And there are several guidelines that have been issued by different regulatory bodies in Singapore. Although these aren't legally binding, they give businesses a very good idea of how regulators may approach AI. And the guidelines emphasize the need for things like accountability, human oversight, responsible data use, and of course, transparency, ethical use of data and AI. So what we would like to turn to next, shifting to mainland China, and let's hear from Zhengwei how China is approaching AI regulation.
And thank you, Winnie. And AI has become a key part of the infrastructure of China's mainland China's digital economy, and that means the compliance in the application of AI technology is now important for corporate strategic planning. In the China's market, on the one hand, domestic AI solutions like DeepSeek are being widely adopted across business and daily life, including leveraging AI to enhance the quality of response to customers' inquiries, design marketing proposals. Additionally, some domestic internet giants like Tencent or ByteDance has deeply integrated AI into searches, social media, and e-commerce. Meanwhile, on the other hand, overseas AI tools like ChatGPT, which is nowadays is still blocked in mainland China, and other AI solutions entering China through so-called unofficial channels, with some users leveraging technical means to bypass the Great Wall, the Great Firewall. This triggers concern about the cross-border data flows and content compliance. And most recently, on March 7th, 2025, the China's Cyberspace Administration, CAC, together with 3 additional authorities, jointly released the measures for labeling of artificial intelligence generated content. We call it labeling measures, specifying the mandatory disclosure requirement for AI products, and the rule will take effect on September 1st this year. And I would speak a bit about the logic of the Chinese legislator or regulators. China's regulation of AI has long been in development. Take AIGC as an example. In 2023, I was invited to participate in a legislative seminar on AIGC labeling, where the focus was on governance of disinformation and mitigation of social risk caused by AIGC's misuse. A few years later, like the beginning of this year, the thinking was embodied in the labeling measures. The regulation did not emerge suddenly. It followed extensive industry research and expert consultation, reflecting China's so-called legislation first, progressive refinement, the logic of them. And alongside with some fundamental rules or measures, relevant national standards also have been issued, collectively forming China's preliminary regulatory framework for artificial intelligence. Like I mentioned, the labeling measures under this rule, entities engaged in AIGC related activities are classified as either service provider or content disseminator, thereby incurring different legal obligations. While in practice, um, I would say more than half of the entities may simultaneously hold both roles. For example, a gaming company using their own AIGC products to publish and disseminate information within its game and player volumes acts the both roles. Given such companies operating in China or they would like enter into Chinese market, uh, at least before this September, must identify their own roles as well as assess their AIGC vendors uh, uh, to for their business operations. And a little bit details about the labeling measures among the series of compliance requirements stipulated in the measures. The most notable is established the dual labeling system, explicit labeling plus implicit labeling. Explicit labeling refers to the labels added to the text, audio, image, video, or virtual scenes that's readily accessible to the users and to avoid any public confusion or misidentification. Uh, but also the implicit labeling refers to the technical label embedded within the file data, which is not easily accessible to the users, but maybe readable for the engineers. The primary purpose here is to record information, including like content attribute information, service provider's name or code, and content identification number to facilitating the regulatory traceability and content management. But this I would say still in a quite preliminary stage, and maybe we have now already seen some operational challenges. We can further elaborate these challenges in a later stage. Yeah.
So what role a particular service provider plays within the AI ecosystem is very important in China. So in determining kind of what laws they will need to comply with. So that.
Yes, they may. China, they have in China we have a fundamental law, and then after this law, we will have some judicial interpretations, implementing rules, and some national standard or even the industrial standards. So we need to combine everything together to see how many obligations we need to satisfy, to fulfill, and what's the legal requirements to act as a service provider. And also, the rules is still in an evolving process, like in Singapore. So we need to establish a dynamic or self-evolving system within the company so as to meet the legal requirements.
Yeah,
And
over
also,
here.
Mhm.
Yeah, go ahead. Mhm.
Yeah. And I would say if you are a market player and you has already been in the Chinese market or plan to enter into the Chinese market, maybe apart from the AI specific rules, we need also to take care of those cybersecurity rules, privacy protection, and also even the advertisement rules. So this will be a comprehensive package we need to look into. Yeah.
Thank you for the very insightful perspective on China's approach to AI regulation. Now let's turn to Australia. Mark, how is Australia approaching the regulation of AI? And what are the key challenges companies are facing down under?
Yep, thanks, Winnie. So the approach is almost a wait and see approach. The Australian government has been in the process of drafting legislation to regulate AI for about the last 12 to 18 months at least. I would say there's probably still at least another 6 to 12 months away from having something that they're willing to put forward to Parliament to then have adopted as legislation throughout Australia. And I think one of the big things is that while they're taking their time with introducing the legislation, they have actually been in consultation with Australian business quite a bit and stakeholders within the area. And what we're seeing at a business level or at a practical level is that much alignment with the EU is looking to be created. And the main reasoning behind that is that a lot of business in Australia will do business overseas with the EU or with China or with the US. And so therefore we're looking, the businesses are looking, and we're advising our clients to look towards the legislation that's in place in these jurisdictions and to adopt measures that are going to help them contract with companies and entities from those other jurisdictions overseas. And to that end, one of the big things that has been adopted in Australia is the AI management standard. And so it is one of 4 standards. So it's an equivalent to, I think, the European AI standard. And under the EU AI Act, there are 4 ways in which you can comply. And one of those is the equivalent to the AI management standard. And so Australian businesses are looking to adopt that standard. And while only one Australian business out of all the businesses in the country has actually been certified as receiving that ISO rating to this date, which commenced on 1 July last year. So it's been in operation for 12 months, but only one business really has been certified. A lot of the other businesses are looking at that management standard and not officially complying and getting the ISO rating, but they're actually implementing the procedures so that when the Australian government finally decides to legislate on this area, it's not going to be a big step for business and a costly implementation of new regimes and catch up so that they can comply with the legislation. But what will happen is that they will have an AI policy or internal procedures that make them compliant with the legislation. And to that end, some of them are adopting spreadsheets that look at what AI is being used, how it's being used, how it's being regulated and updated, who's the responsible person for looking after the use of AI in that corporation. And more often now, we're starting to get a lot of companies, which we're recommending as well when we speak to them, is to develop those internal AI policies and even take that next step and give an external AI policy to promote transparency. And one of the big pushes behind that is that Australian companies are thinking we can use this as a marketing tool, a marketing lever to say, yes, we use AI, but this is how we use it. We're going to be transparent. If we have your data, only certain data will be used by the AI. Other data will be kept secure and safe in other areas. The AI we're using is potentially one of 4 different levels, similar to what Jen Wei was talking about earlier when they were saying, the restrictions, and this is likely under the Australian legislation when it comes, will categorise AI into at least 4 different categories. So you'll have your first level AI, which might be your Microsoft Word AI, which predicts what you're going to type next in your sentence. And then the next one could be a step down where it's actually helping you respond or spot errors. And then, category 4 though, might be where AI acts independently of human oversight. And so at that level, it's expected there's going to be a very high degree of regulation because Australia is pushing towards the human oversight model for AI implementation.
Thank you. Thanks, Mark. And would any changes or adjustments to the timeline for implementing the EU AI Act kind of affect the Australian plans towards regulating AI?
Possibly, but to the sense that I would see it more as the EU companies pushing back on the Australian companies saying, oh, we now have to be compliant. If you want to continue doing business with us, you must comply with that AI management standard or provide us with indemnities to say that you're going to hold us harmless in case you breach these things. But more so, it is aligning itself with Australian businesses, and I guess on a slightly tangential analysis is the way in which the environmental rules out of the EU have come about and are impacting on Australian business in terms of tracing back products through to their original state. In the same way, the AI concept now is you need to be able to trace back that AI through to its original decision-making process and be able to explain that if you're using AI, how that AI is it's an interesting concept there, and how that AI is actually making the decisions for your business.
Okay, so having explored kind of the various regulatory frameworks around AI, let's now shift our focus to kind of the critical data risk involved in using AI within the workforce. What are your thoughts on kind of the primary concerns companies need to address when it comes to data security, employee privacy, or potential biases in AI-driven decisions? Zhengwei, would you like to give your thoughts, on this issue?
Okay, thank you, Winnie. I would say a couple of issues need to be addressed based on the current legal framework in China. First is still the uncertainty of the legislation and enforcement trend. Although we mentioned from time to time we issue new rules and new standards, but it is still not clear what the consequence will be if a company violate any rules or regulations, or they fail to fulfill its legal obligations. Now all the AI related rules just mentioned, violation will be handled in accordance with other relevant laws and regulations. And so-called those punishments could range from fine to orders for business suspension. If a company has been suspended, has to suspend operations, it will suffer significantly damage to its normal business and reputation. And also, like I mentioned, many companies, even the local companies, will adopt like overseas AI tools to facilitate their work and products. And so the regulations are also lacking details about data compliance requirement when AI products or content generated overseas and transmitted into China for use. Now, the different logic from Chinese legislators and the Western legislator is data in EU and the US and other jurisdictions, they will treat the data as personal belongings, and you need to enter into contract with the subject of the personal information or data and the service provider. But also in China, they will treat this as a part of the sovereignty of the Chinese regulation or Chinese authority. And so they take really care about the how the data transmitted outside of China, but still not a black and white rules how to treat the data transmitted into China. This brings uncertainty. And also when we talk about the AIGC's labeling, let's do an example like a education company or even a game company. If an education company use an AIGC tool to enable real-time dialogue or conversation between an AI teacher to a user or student, each round of the dialogue need to be labeled, or we just can label it at the very beginning, say, oh, this is AI generated, and then you can continue the dialogue, or in a game scenes, and you can talk with the NPC without any AI labeling. So strictly enforcement could disrupt the user's experience, while simplification risks non-compliance. Also, the last thing I would say, yeah, this is also related to our industry, like professional services. Like, I come from a law firm, so how we can provide our legal service by adopting AI tools in the meantime to meet the confidentiality requirements from our clients. So if a firm use AI tools to analyze questions raised by the clients and the confidentiality provided by the clients, a firm will face the challenges how to ensure the data security. In current practices, safeguarding of the data security and confidentiality during using the AI products relies primarily on the privacy policy and the user agreements applicable to the AI provider. And on top of that, we may invoke the confidentiality clauses in the engagement letter or agreements, uh, and alongside with the legal professional ethics and attorney-client privilege. In the other words, every different industry, their requirement for the confidentiality or even privilege can vary. So we will see some fundamental rules together with certain industrial standards or guideline in this regard. But still, this is blank and to be provided in the future. But now I would say in different industries, the major market player will narrow their gap and have an agreement to provide a best practices or common practices in certain industry. But this approach may prove inadequate in face of potential future regulatory tightening, but we will see. Well,
Interesting. Thank you. And Patrick, do you see similar operational challenges and compliance risks for businesses implementing AI solutions in Hong Kong?
I think the biggest risk, and this is global, it's not specific to Hong Kong, is what you might describe as the risk of unintended consequences. So if you look at a number of particularly Gen AI tools that are being promoted at the moment, there is an ease of use and a quality, or at least an apparent accuracy in respect of responses you get. That means that adoption, with most new technologies, the biggest risk or the biggest challenge is adoption. But adoption in respect of Gen AI tools in particular is there's a strong uptake. And what that does is it creates the speed of adoption and implementation is faster than is necessarily appropriate in respect of the particular business in question. So you might find that businesses haven't asked questions like, what specifically are we looking to achieve by the adoption of this AI tool? What data needs to be made available, and how does it need to be organized in respect of before we release it into the system or make it available for processing? What data sources are being used in respect of the AI tool that's actually being deployed across the organization? Do they have rights to the underlying sources that they are using in respect of the training data or in respect of the outputs that they're delivering? What use is going to be made of the whatever we might upload to the AI system itself? Is that something that is going to then become available and be part of a training data set? What should we do in respect of managing personal data and personal information to make sure that it remains secure and also compliant in respect of privacy obligations. All these kinds of decisions need to be made before you sign a subscription and make something available across an organization. And that really requires a more methodical framework, a governance framework, a decision-making framework before you move ahead. Otherwise, all those unintended risks might well come and vest, because it's so easy to rock and roll with some of the systems that are coming out. Another risk that often, I think of artificial intelligence as being a cluster of different technologies rather than a single technology. So the idea of thinking that it's a one-size-fits-all, as in you have one AI policy and that's fit for purpose across the entire organization for all reasons, doesn't particularly work that way. So if you look, for instance, in financial institutions, they may use AI systems to help in respect of transaction monitoring and AML compliance in respect of transactions that are being processed by an institution. But that's got an entirely different set of risks and potential liability that might arise in respect of how you would devise and implement a system like that, compared to, say, someone who might want to adopt and make available across their organization something like a commercially available Gen AI solution, like maybe Microsoft Copilot or something of that nature. Very different beasts, very different concerns, a very different approach in terms of how you introduce it into the workplace and make people aware of what they should or should not do in respect of the systems that are then available for them.
Yes, I agree. With the point you mentioned as well, it's so important to have a very clear AI data policy, where your policy will specify and outline what AI systems and tools have been approved, what types of data sets will be used, and how data will be stored, protected, and retained. So over to you, Mark. Do you think that current standard confidentiality clauses in employment contracts are sufficient to maintain data security and confidentiality where employees use AI tools? Or do you think some potential changes need to be made, to the existing employment contracts?
Well, I think it's almost a loaded question, in the sense that it's not so much that contract, but it comes back to the practical situation of, and this sort of incorporates some of those questions that have come through from the audience in terms of, I would say, my recommendation in this area would be, first you must ask of the AI system how it deals with the data. Is it a sandbox environment, for example? So if it's a sandbox environment, then yes, you can put your confidential information into there because it's not going outside your organization, and so therefore it's four-walled and it's kept within the organization, and so it can't be disclosed. But one of the biggest concerns, especially with employees that we're facing in Australia, and especially for our firm itself, with law firms, we have legal professional privilege, for doctors who have their client-patient privilege, for accountants who have a similar type of privilege. All these professions and businesses that have to abide by elements of confidentiality, they really should be not implementing AI until they work out what is being done with the information that goes into that AI system. And so that really is that first point of call. And then in terms of whether it's going to bind the employees, well, the reality is employees are going to use AI. And so business largely across Australia is now trying to adopt an approach whereby they're almost embracing the use of AI, but educating the employees. So rather, yes, you've got your confidentiality provisions in the contracts, but it's more of an educational piece here where the business needs to tell employees what they can and can't put into these different AI systems. Set up processes whereby if an employee wants to use an AI system, they're not afraid to use it, but rather they'll come to the chief technology officer and say, I think using this AI system is going to be great for our business. So the AI officer or the CTO can then look at that AI system, see what its benefits and stuff, do the deep dive into how it uses the data, and then come back to the employees and say, yes, you can use that, but only in this situation. Or, yes, it's great to use across the board, or no, you can't use it at all. And so I think that comes down to that educational piece, more so than putting confidentiality clauses into a contract. Because, yeah, as I said at the outset, employees will use AI no matter what you say. It's about directing them to the best AI for your business and the most appropriate AI for performing that particular task. Similar to what Patrick was saying earlier, it's not like a one-size-fits-all. You need to think of it like a builder's toolbox. You're not going to pull out a hammer to cut a piece of wood in half. You're going to pull out the saw. So you've got all these different tools out there that can do different jobs. And what you want to do is educate your employees so that they know which tool to use in which situation and what they can actually do to put the right input in without compromising confidentiality.
Thank you. Thanks very much for your perspective on this issue, Mark. Zhengwei, do you have anything to add?
Yeah, I would say, like Mark mentioned, the compliance awareness for all the employees will be the most cost-efficient approach for every company to control the risk. And also, this will be a hybrid legal issue, not specifically related to AI. Also, the compliance, how to sign, how to design the compliance clauses, and how to update our internal handbook or internal policies, and how to impose the disciplinary actions against those employees with misconduct. And also, more importantly, I previously worked as a investigation lawyer, so we need this is a timing for us to need to upgrade our investigation approach and methodology. So that this will be some more topics to be discussed in this regard.
Yeah, the key to managing and mitigating AI risks, especially around data misuse, starts with a very solid foundation of understanding. So as all my fellow panelists mentioned earlier, first, companies should really get clear on why they're using AI in the first place. What are the specific use cases, and how does AI add value in each case? Very often, companies need to conduct a very detailed cost-benefit analysis that helps ensure that the rewards outweigh the risks. Be very transparent about the risks, and have very clear process in place for addressing them. So what are your top tips in managing and mitigating risks arising from AI use in a workplace? Perhaps we'll start with Patrick.
Well, I think, to me, the first top tip is to get buy-in from senior leadership. Because the starting point, where you want to end up at, is to have a governance system that actually works and is effective, that is more than just a paper policy, but has got cross-functional roles where you can assess the utility of AI systems you might want to deploy, but also has an oversight mechanism and a feedback mechanism, so you have the ability to be able to maintain the currency of whatever assessment you make across the organization and across the lifespan of using that particular AI system. And in order to be able to resource that, the starting point and the magic ingredient is to have real effective buy-in from senior leadership. And that requires a degree of engagement, a degree of education, and a degree of lobbying in order to make sure that it goes beyond what you might say, a senior executive saying, AI, yes, let's, that's cool, let's do that, to something that becomes a serious business issue that is then managed and worked across the organization in the same way that things like data privacy and privacy management programs have done so, that cybersecurity and cybersecurity management programs have done so. AI fits very much within that kind of framework. And for all those programs that are effective, it starts with senior leadership awareness, buy-in, and support.
Thank you. Thanks very much for the insights, Patrick. What about Mark? Do you have any favorite tips, for businesses?
Yeah, so, well, one of the things I am doing for a lot of my businesses, I actually give them a spreadsheet. And that spreadsheet will have columns that basically lists the AI, what it is, what it's to be used for, how you're conducting regular checks, who's the responsible officer, what sort of education or training needs to be done before you can use that system, and what parts of the business is it going to be applying to, and a few other columns like that. And so if businesses adopt a spreadsheet along those lines and are able to fill in those things, that's going to be our first step in any ability to trace back when there is, for example, a data incident or when that AI is compromised. Because one of the big things that we know about AI is that it's constantly learning. So the answer it gives today or the output, I should say, the output it produces today may not be the output it produces in 12 months' time. Now, depending on the business may want that that output to be the same in perpetuity. So the business will need to know at what point during that 12 months it changed. So having this sort of a log whereby you've got continual checks being done, you know what AI you're being used and the purposes, it helps the business maintain that consistency for the use of the AI system. And that would be my number one tip, to maintain something like that. Because it will also help in other things such as, if there is a misuse or vulnerability, you'll have that sort of backup to say when you loaded that AI onto the system, when it was noticed, when wasn't it working well.
Yeah, it's useful to appoint, whether it's someone or a committee, whether it's AI officer, data protection AI officer. So it needs to be kind of clear in your particular company, because the relevant group of experts, including your internal stakeholders, compliance officers, should be ready to handle any incidents or breaches. So there should be very clear escalation protocols for when things go wrong. Who internally they need to reach out to.
Yeah, spot on.
Okay. Great. What about your thoughts, in relations to kind of off-the-shelf AI products? Our view is that we do encourage businesses to take the time to really evaluate the contracts and the agreements, even though they're using off-the-shelf AI products. Patrick, do you have any additional?
I think it's always, there's a tendency. I mean, as a lawyer, I always say read the contract, but there's also the point that you may not necessarily be able to change much of the contract in respect of the large commercial suppliers, and there is an element of business practicality that you might, you don't have the ability to negotiate. But at the same point in time, you can't just trust the brand. It doesn't absolve you from understanding what is happening to the data that you're inputting, or in terms of what you expect might be coming in respect of outputs that an AI system is delivering. So simply because it is something that is maybe a reliable commercial provider doesn't mean that you can just hang your coat on that and forget about the rest. It still is something that you need to govern, manage, and understand.
Yeah, true, very true. So when working with AI vendors, make sure we all do our homework. Don't skip the due diligence process. Check on things like how they train their models. find out whether they have any safeguards in place for international data transfers and what data security measures they have put in place.
And on that point, Winnie, with the international data transfers, that is becoming a bigger consideration now more than ever, especially with the use of the AI, with giving it access, and the off-the-shelf products are generally connected to an international network. And so you need to know whether your data is being transferred into international jurisdictions. A lot of legislation I know in Australia, it talks about the data needing to be maintained in Australia. Otherwise, if it goes overseas via one of these AI systems, then it needs to be disclosed in your privacy policy. So the use of these AI tools, especially the off-the-shelf products, really does need to fit sort of hand in glove with your privacy policies and a lot of the other governance policies of the business. And so you can't, as Patrick was saying, you may not be able to change that contract, but you need to be able to know what changes you need to make to your own policies in your business so that you can use that off-the-shelf product without breaching your existing policies or your internal country's legislation.
Thank you very much. Looks like we have to wrap up. So thank you so much. Thanks to all our panelists and attendees for this very insightful webinar session. In conclusion, AI holds very great potential for businesses, but it also comes with its fair share of challenges in terms of regulation and compliance. So it is very important to stay informed and proactive to navigate this AI landscape very successfully. So thanks again for joining us today. And we hope that this conversation has given you some useful insights for your AI journeys. Thank you.
Thank you.